Okay, so the argument I want to make today, and I changed the title a little bit because I realized I deal actually so much with pre-war Japan that it makes more sense to talk about property laws, housing policy in 20th century Japan. But the post-war is really where it comes into its own. But the argument I'm going to make today is essentially that property law and the way that property rights were structured in Japan served as a really radical form of housing policy and a system for protecting renters throughout maybe the second half of the 20th century, right up until the last couple of decades when it really came apart. And this was built around two laws, but it was also built around a larger interpretive regime of those laws. And so I'm going to try to give an account of both sort of the legislative and the sort of intellectual political side of this whole regime. But before I jump into that, I guess I want to set it up with maybe with just an observation and sort of trying to position myself and where I see this paper ultimately going. And that is essentially that Japan, let me rephrase, where you have within the historiography of Western industrialized economies, the United States, England, Sweden, Finland, etc., the welfare state looms as this sort of enormous meta subject of history writing. It's been studied from almost every single angle. The sort of volume of work on it is just stunning. I did a couple just sort of quick searches in Columbia's library catalog, and you just get thousands and thousands of hits when you look up when you search history welfare state and sort of any of the United States or sort of major Western states. And by contrast, in Japan, the welfare state has really never risen to be a major topic for historians. There's sort of policy studies. I think those are actually somewhat scant, but especially for historians, they've never really seen much need to examine welfare policy or the welfare state in general. In English, I'm aware of really only two, maybe three major studies of social policy about Japan. And in Japanese too, I was kind of stunned doing research for this paper, how little actual historical work there is done on Japanese welfares. So while we have a somewhat account of kind of very standard and familiar set of the sort of standard and familiar set of institutions that we associate with the welfare state, we really don't have much understanding of sort of their intellectual origins, their implementation, or really their social entailments. And it's not because people just don't get it. In some ways, I think there's a good reason for this, and that is that if you look at the Japanese welfare state at a pass, it looks tiny. So this chart is for 1990, and it shows social spending and tax and social security spending in Japan. And Japan is really in the bottom of major industrial economies. It's just a total outlier in how little the welfare state is, even smaller in some measures than the United States. Japan's social spending levels are low, its tax revenue is small, and the benefits, its social benefits and direct social provision, poverty relief, et cetera, are sort of absolutely meager. So at some measure, the Japanese welfare state looks small and totally unimportant. And yet, if you really think about it, there has to be something else going on, because over the 20th century, Japan transformed from being one of the more unequal industrialized economies in the entire world. You know, think about the early decades of the 20th century, and especially during the war in the 1930s, when Japanese farmers were literally starving to death in the Northeast. And contrast that with, you know, these surveys in the 1970s when something like 90% of the country responded that they saw themselves as middle class. Part of that is about ideology, but also it's very much about an enormous amount of sort of social and socioeconomic leveling that took place in those decades. And so something clearly is going on. And I think we can get an understanding of that if we start to think of welfare not simply as a set of kind of familiar institutions that we know from Western welfare states, such as Social Security, unemployment insurance, poverty relief, et cetera, healthcare. But instead, following Epstein-Anderson, we think of welfare fundamentally as forms of decommodification, and think very broadly about how this could take place. So if we start to look for sort of functional equivalents to familiar welfare policies and institutions in Western welfare states, I think we can start to see how more social policy, at least, and welfare policy in Japan is far more pronounced, and in some cases really radical, far more radical than it's been given credit for. So housing and housing policy is a really, I think, good example, and this is where the rest of the talk will go. If you look at Japanese spending in public housing throughout much of the 20th century, it's risen actually since the 1990s, but up until the 1990s, it's just minuscule compared to comparable major industrialized economies over the same period of time. And yet, Japanese, I'll stay on this for a second. Japanese renters, in fact, during the same period, enjoyed some of the most robust legal protections of their status within any major economy in the world. Not only was it really exceedingly hard to remove a tenant once they were already renting a property, it was even very difficult or prohibitively expensive to refuse to renew a tenant's lease. And thus Japanese renters could essentially renew their lease, usually with only a very minor increase in the amount of rent they were paying indefinitely. Their landlords had extreme problems kicking them out. And I just want to use one example. There are plenty of court cases that sort of bear this point out, but I want to use one example and that I brought up in my paper, just to sort of communicate how extreme, how the extent to which Japanese courts would defer to tenants' interests when these cases would come in front of the Japanese judge or judge in general. So in 1991, Hiroshima University professor who owned a house in Tokyo, he decides he needs to move to Tokyo with his wife to take up residence. He's gotten a job at Tokyo University, and he has to move to the city. So he's been renting his house in Tokyo for years then, and the tenant is still lodged in place. And so the professor decides that he's going to wait for the tenant's lease to expire before trying to take over the property himself. And during this time, he lives with a son in Chiba, so a little bit out in the suburbs to the east of Tokyo. And while he's living there, his wife and his daughter-in-law, apparently they start to fight. His living condition becomes terrible. He needs to sort of move out. It's too far of a commute. He has all these reasons that he submits to the court that he needs to take over his own property. And so once the tenant's lease expires, the court actually does recognize that this judge has sort of what they call a just cause, a sort of immediate and personal need to take over a property. And yet, even so, the judge orders that in order for him to sort of refuse to renew the tenant's lease, he needs to then pay the tenant what is essentially 10 years of back rent as a sort of moving out fee. So just an enormous sum. And these kinds of cases are common across sort of the case law in Japan in the sort of in the post-war decades. And I guess the only other point to point out here is that not only was it difficult to sort of evict a tenant or to terminate a lease or to refuse to renew a lease, but this proscription against getting rid of a tenant functioned as a form of kind of de facto rent control. Without the threat of eviction, landlords really had little leverage to raise rents. And also, if the matter ever did come before a court, judges were very wary about prescribing too drastic a rent increase. And so the result was that the longer a tenant stayed in an apartment, the lower the overall rent was compared to everything else. So according to a 1988 housing survey, tenants who had initiated their leases before 1946, so just before the end of the, or just right after the end of the war before then, were paying about half the rent per month as tenants who had started a lease in 1980 or between 1980 and 85. So a really drastic sort of form of, a significant form of rent control was also imposed by this system. And if you listen to the critics of this system, you get a real sense of how significant it was. Frank mentioned Mark Ramsayer, and actually I brought a quote from him. He hates these laws. He sees them as sort of or this sort of legal regime. He sees it as a kind of distortion of the market. And he writes that, in effect, it is a world where judges give tenants the right to extort huge sums of cash in exchange for leaving. And legal predictability being what it is in Japanese courts, it is a world where bookstores stock volumes and websites post tables explaining how to calculate the size of the extortable cash a tenant can get from his or her landlord. So this is really a kind of radical housing regime in some measures. And with the rest of this talk, I really want to talk about sort of how it came to, how it emerged historically, and also touch on its sort of dissolution in the 1980s and 90s towards the end of the 20th century. Yes, and to do this, I found it sort of useful to sort of split this history into two different sort of approaches: a kind of formal legislative one, basically a history of the laws and legislation that sort of were the foundations of this regime. And in the paper, I go into some more technical detail, but I don't think I'm going to really delve into it today because I think it might just be a little bit excruciating. But if we have time, I might touch on it a little bit. And then parallel to this sort of institutional or legislative history is really a very crucial one, which is a political and intellectual history of how these laws were then sort of interpreted and reinterpreted in pretty profound ways, both by professional jurists and also by activists and tenants who were sort of pushing their claims in courts. So Frank brought up Japanese judges, and I agree. I think you can't understand how the system worked without deference to the amount, the significance of the courts in really transforming what is kind of a minimalist legal regime into a very robust regime for protecting renters. But my focus today is largely sort of on what was happening around the courts that kind of forced their hand, at least as I see it. Sort of this kind of elite jurisprudential, theoretical sort of reinterpretation of property and rights and the law, and then also sort of a little bit the social movements that sort of really kept these issues on the front burner in Japan. So with that, I guess I just want to jump in and touch very quickly on some of the technical detail. I think it's really hard to understand what's going on with any of this if you don't have a basic grasp of how Japanese real estate rights differ, at least from the United States. And if there are people out there who can tell me, I would be very curious if how this compares to Taiwan or other countries in East Asia. But in Japan, in essence, a building and ownership of a building is divorced from the land the building stands on and ownership of that land. And so what you have is essentially, I hope you can see this cursor, but you have ownership rights that are specifically for the land. Above that, there might be a lease on the property rights. The land lessee, in Japanese, the shakuchijin, may then build or own a building on the land. And that person also would then rent to a tenant who owns nothing but has a sort of contractual relationship with the building owner. So for any one piece of rental property, you can have up to really 4 legal relationships between the landowner, the land lessee, and then between the building owner and the building or sort of room lessee in this situation. And I think just by looking at this sort of schematic, you can see how the possibility for complication is right. I mean, it's kind of hard to grasp, I think, or just to get your head around it instantly. And as things get kind of muddied and contested over property rights, the possibility for real major complication just spirals out. And indeed, that's exactly what happens. These rights are really set by the 1898, the finalization of the Civil Code in 1898. And almost instantly, there are sort of fights between land lessees and landowners over the quality or the sort of the relationship between them, and also the sort of the status of building ownership versus land ownership. All of these things are immediately problematized as soon as these legal rights are formalized by the new Civil Code in 1898. And the land and house lease laws, which are the sort of foundation of the housing regime that I'm talking about today, they are sort of passed as a quick measure to try to stop or to try to address the sort of the rising amount of social conflict that comes in the first 2 decades after the Civil Code is promulgated. So there's a sort of a long simmering history of trying to address the imbalance of rights between land tenants and landowners. But as you can see in this chart, by the time the laws are put in place, the real crucial issue is actually about building tenancy and the status, or how to help, or how to maybe try to stem the tide of a huge number of building eviction cases that really take off from the 1910s and then just continue up all across the interwar period. I think what's important to understand here are 2 things. Is in this period, Japan is undergoing, in this period sort of leading up to the spike of cases, Japan is undergoing major structural changes. So early industrialization and a sort of a wave of urban migration has fundamentally transformed what Japanese cities look like, and also their composure. It was kind of rare throughout the 19th century for there even to be building tenants. They were sort of the dregs of society, day laborers, people who had to live in these long houses, and were rather rare, even relatively speaking, within Tokyo. But as you get a real proletarian labor force or industrial labor force in the city in the 1910s, and as prices start to spike, and as landlords start to demand increasing or higher rents, and also to look for ways to sort of get more money out of their properties as construction prices are rising, and also as land prices themselves are rising. So many of these building owners have to pay higher rents to the landlord for them too. So they're then try to extract more money from their building tenants. As all these things are sort of compounding, you get this sort of huge spike in eviction cases. So you can see it in the graph, but I just want to give you a couple numbers. Essentially, petitions to evict a land lessee in 1911, there were 304 in 1911. By 1918, the end of the decade, that had basically doubled to 518, the highest figure for the decade. But of course, the real story is what's happening to building tenancies and building tenants. They're already flooding the courts by Japanese standards in the beginning of the decade with almost 2,000 cases. By the end of the decade, there are more than 5,000 cases, so more than doubles. And then by the 1930s, we're into the 20,000 cases. So just a huge increase in the number of building and tenancy problems. And when you see this graph, you should also keep in mind sort of a mental image of this. Not only is sort of Japan undergoing major structural change, but it's also a kind of high moment for international socialism, anarchism, communism, and major political activism from the left. So the Russian Revolution has sort of shocked the world, and within Japan itself, the early 1920s are really the sort of high tide or high moment for pre-war leftism. It's before the sort of left-wing parties are made illegal, and activism is sort of everywhere, and there's a lot of sort of agitation within the streets. And so not only is this sort of a kind of numerical issue when looked at from the perspective of politicians in the Diet or from urban planners, it's really a kind of major political crisis, as the fear of a real revolution from the left or violence from the left in Japan at this time is really at its peak. And so the house and land lease laws are really a kind of response to this sort of intense anxiety about the threat of sort of revolutionary violence, or at least the threat of revolutionary activity in Japan at the time. What the laws do is a little peculiar, though, because considering that the problem is high rents and evictions. These new land and house lease laws address this issue rather obliquely. Under the civil code, essentially, most forms of tenancy, building tenancy and land tenancy, were categorized as simple leases or simple obligations. And in this sense, they were contractual matters between specific people. And rather than a real right, which is like a property right, which is exclusionary and alienable, only a small section of land leases were sort of categorized as this. And for everybody else, their claim on the land they were renting was essentially recognized only as a matter of contract. And the long short of this is that it exposed the tenant to the threat of sort of immediate eviction should the landlord decide to sell the property. And what the land and house lease laws do is they essentially close this loophole. They make both land leases and house leases exclusionary, regardless of registration or anything else. And this means that if you're a tenant in a Tokyo apartment at the time, and your landlord decides to sell the property, doesn't matter who he sells to, you're still entitled to continue leasing the property under the terms of the original lease. So that's legally, it's quite radical in some respects, because now the tenant has a claim to the property that is sort of direct, is a real right in the property itself. It also sets minimum terms of leases for land leases, and stipulates that the landlords need to give tenants a kind of a minimum period of notice before they evict them. So at a time when the Japanese economy and Japanese law is sort of classically liberal or laissez-faire, this represents sort of the beginning of direct state intervention into the legal system, where sort of you get some regulatory framework set up. Yes, but the main thing is essentially these laws, what they mainly do is they close that loophole and prevent immediate eviction in the instance of sale, which was one of these sort of legal tools that landlords were using to both get rid of tenants or to threaten their tenants if they didn't agree to pay higher rents. It was not intended to be a radical adjustment in the way Japanese property relationships worked. Instead, in sort of the words of the man who wrote it, let's see where that is, the Minister of Justice, Miyako Shotaro, he believed that these sort of new lease laws would actually foster consensus among renters and landlords and force them to sort of work together more equitably. If we go back to this chart, we see that absolutely that the opposite took place. After the lease laws are passed, you really get even more eviction cases, and the courts are sort of even more inundated